This is SJC-13180, John L. Tocci v. Michael J. Tocci. Waiting for Attorney McCarthy to turn on your video, please.
Sorry about that, Your Honors.
There he is. Okay, we're ready for you.
Good morning, Your Honors, and may it please the court, Gavin McCarthy for William Tocci and Tocci Corporation. There's a number of different issues in this case, so I'll start with surcharge, but of course, jump in on whatever issues the court is interested in. This attorney's fees question here, at least the narrow issue, is an issue of first impression in this court. It's well established that surcharge is an available equitable remedy, but the court has never had the opportunity to consider whether it can be applied to require the reimbursement of attorney's fees spent by a close corporation in prosecuting a breach of fiduciary duty claim. That's a purely legal question. Ultimately, there would be a discretionary question for the trial court, if they're authorized to consider this, to look at all the factors that trial courts consider in deciding whether to grant fees and to what extent. But the first step has to be the authorizing question. Do they have the power to do this if they think it's warranted on the facts? And that's not a question this court has yet had the opportunity to consider. I would suggest, though,
we have definitely addressed a lot of shareholder derivative suits, both this court as well as the federal, our federal counterparts. And are you aware of any cases where the award of attorney's fees is available as a surcharge in any of those cases?
in the shareholder derivative cases, I've never seen it addressed one way or the other. And the reason
I guess I'm wondering why you think that's the case, given the plethora of those kind of cases that exist.
Because most of the time, the common fund doctrine as a practical matter is good enough for the beneficiaries. So most of these cases, you have a minority shareholder who owns 5 or 10 or 15% of the company suing. And so if the company reimburses that person's attorney's fees, they're getting virtually everything that they would get from surcharge. So there's no need to fight the separate fight to get the extra 10%. You're basically getting yourself there, and you have a well-worn track of law to follow. There are lots of cases, including the restatement and dozens of cases collected there, in which fees are awarded in the trust context in these exact circumstances. So you sue for a breach of fiduciary duty by the trustee, and surcharge is applied to allow reimbursement from the breaching fiduciary to the trustee. I've never seen any court ever reject that application of surcharge, neither in Massachusetts nor anyplace else.
Right, so it seems to me it makes sense in the trust context. It makes sense in the bankruptcy context where there's a bankruptcy receiver appointed. It makes sense in the ERISA pension plan context, but why do you think we should extend it to allow shareholders or to allow the company to reap these attorney's fees? Isn't that just encouraging these kind of suits in contrast to the ordinary American rule where everybody pays their own way?
I would say quite the opposite, that the policy provisions point toward allowing attorney's fees here. Because this is,
you're just saying that, you know, in all these cases for the last, you know, X hundreds numbers of years, nobody's ever awarded attorney's fees, and it's good enough to have the common fund doctrine. Why isn't it good enough in this context?
because when the corporation itself is suing, and when it's majority owned by the folks who did not commit the breach of fiduciary duty, almost all of the recovery is going to be eaten up by the need to spend 8 years of litigation chasing the wrongdoer. So unlike in those common fund cases, the derivative suit, they get 90%, let's say, of their money's reimbursed. And so the company gets its money back and the beneficiaries are made essentially whole. In this case, the innocent shareholders own 2/3 of the company. And so when the $1 million plus interest comes back, and they've spent 8 years going through 2 trials and an evidentiary preliminary injunctive proceeding, and I can't even remember how many discovery disputes and all the stuff that goes along with litigating for 8 years, there's very little left for the beneficiaries, and they're eating up 2/3 of this because, unlike the typical case, they own 2/3 of the company.
Can I ask a backup question? I've read these surcharge cases, but because you're allowing surcharge, they're not. I don't see them allowing attorney's fees in these other contexts either. I understand shareholder derivative suits are different, but I looked at the cases cited where there's surcharge allowed. They're not giving attorney's fees. The ERISA case by the U.S. Supreme Court, there's nothing about attorney's fees in there. The trust cases that cited, I don't see there's attorney's fees awarded. There's a surcharge, but I don't see they're giving out attorney's fees.
So there's two different categories of cases. There's one category of case in which surcharge is applied specifically to authorize attorney's fees.
Can you give me a citation? Because I'd like to actually see a case where a surcharge gives you attorney's fees, because I can't. I've read a number of the cases in people's briefs. There's no attorney's fees in any of those.
So there's at least 3 cases I can think of off the top of my head. Crutcher v. Joyce.
Crutcher, and where is Crutcher? Is from where?
I don't remember all the jurisdictions. They're non-Massachusetts cases. One of them is, I think, from Washington. One of them is from the 10th Circuit. I think Crutcher is a 10th Circuit case.
And they gave attorney's fees in what context?
They are breach of trust cases. So beneficiaries suing a trustee for breach of fiduciary duty in connection with the administration of the trust.
And it's not, there's not a contractual right somewhere or something expressly providing. They're using this surcharge doctrine to create an attorney's fee right.
That's exactly right. So the Heller case from Colorado does that. The Crutcher case, which I think is from the 10th Circuit, the Allard case from Washington, and the Restatement of Trusts, Section 100, not a case, obviously, but it's the restatement, describes expressly that this is a well understood use of surcharge, that historically it has been used for exactly this purpose.
To provide attorney's fees.
That's exactly right. The comment, and I think it's comment B, but the citations in our brief, it's absolutely expressed in the restatement that one proper application of surcharge is to require a breaching trustee to reimburse the attorney's fees spent proving the breach of trust.
Are these cases though different? I mean, like here we have, a family feud where, we got both sides have fiduciary duties to the corporation. Like I understand, like ERISA seems different to me. We've got, we've got these sort of defenseless employees whose pensions are at stake. Are these trust cases also examples where you've got sort of someone who's entitled to protection and another person who's required to protect them, as opposed to here where we've got both sides owe the corporation a duty. They both owe fiduciary duties to each other. And it's just, again, family fighting.
Well, certainly both sides owe fiduciary duties to each other, but only one side is said to have taken money from the company, and it's the company that's suing here. So in that respect, they're just like
the company is fully reimbursed. The company is back to where the company was before. The company, yet the only issue is one of you has expended attorney's fees to provide, to create that reimbursement. One of you is out of luck, but the company's back to square one, right?
Well, not on a net basis, because the company spends the money to get the reimbursement. And so on a net basis, it pays for the attorney's fees. It spends 8 years doing it, and now it is ordered to get money back, but then it has to pay its lawyers and its experts and its vendors and all this stuff. And on a net basis, it's much, much worse off than it would have been. And I would just note on the policy front there that both this court and the First Circuit applying Massachusetts law has noted the importance of having a liberal attitude about fees in these contexts. So,
Mr. McCarthy, I want to go back to Justice Wenham's question, though, because as a Superior Court judge, there's no more difficult cases than civil cases when families are fighting about how much they hate each other and litigating how much they hate each other. And what's going to happen to those type of cases if we add the ingredient of not only do you have an opportunity in litigation to manifest your feelings about your family members, you might also get attorney's fees for doing so.
Well, if you prove a breach of trust by one of the people, this isn't like a family law case where they're fighting about, did I get fired from the company?
No, those aren't the type of cases I'm referring to. I'm referring to the many, many, many cases like this that I had in the Superior Court, where the underlying ingredient for the litigation wasn't often the amount of money at stake.
Well, often I would say a lot of those cases are oppression cases and freeze out cases. Those wouldn't come within this doctrine. Those are not analogous to the breach of trust cases. What makes this analogous to the breach of trust is the taking of money. And so it's closely analogous to a pension trustee who's supposed to be responsible for managing money and who instead takes it. And in that circumstance, so I don't think it's all those cases. It's not just going to lead to a proliferation of litigation among family spats. It really is limited to close corporations, breach of the duty of loyalty, where you have a taking of money. And I would say,
won't you get it in every case where there's an allegation of excess compensation? I mean, I like Justice Lawyer, I had a lot of these cases, these close corporation cases, you know, and family businesses, and one person's in charge, the other ones allegedly don't do the work, and the other person gets paid too much. We've seen this movie.
Certainly, an excess compensation case would be one variety, one manner of taking, and I agree that the principles could apply in those cases. But again, you have to prove it. And so, you know, we should not be cutting off the beneficiary who can ultimately win and show that there was excessive compensation or that there was a wrongful taking by making it impossible.
To what extent do we count or just look at the value of the corporation that was largely driven by the defendant?
I'm not sure what Your Honor means. To what extent do you look at the value of the company?
So you're talking about the you're talking about the diminution of the company, but the argument I think you're going to hear from the other side is that the brother who ran it actually built the company.
And that might be a defense on the merits to some excessive compensation cases, right? Plaintiff comes in and says, you paid yourself $100,000, it should have been 30. And the defendant says, no, 100,000 was appropriate. Look what a great job I did in building the value of the company. That person wins on the merits, if that's true, and there's no attorney's fees award. Right? So attorney's fees only get awarded if a plaintiff proves that there has been a wrongful taking in violation of these strict duties of good faith. So the floodgates are not just open. These are hard things to prove, as this case shows. It takes a long time and a lot of evidence and a lot of money to get to the point where you can prove a wrongful taking of, especially the magnitude proven here.
Counsel, can I ask you to switch gears for a second? I know that time is up, but with the chief's permission, I'll ask the question, why is the cross-claim not right here? I mean, it seems like your client had for over a decade. These breaches happened in the 80s and 90s, and the case was brought by your clients in 2016, I guess, was when the relevant complaint issued. And as Justice Kafka pointed out, one of your clients had a fiduciary duty to the corporation to monitor the books. I just don't understand why we're here. Why is the statute of limitations not run?
Well, you have to have actual knowledge of the breach. So,
right, but you also have a fiduciary duty, one of your clients does, to monitor the books. And some of these things happened, I think all of them happened more than a decade ago. So can you just address why this is right?
Yeah, so
let me start from the beginning.
The case law is really,
No, let's not start from the beginning. I guess I'm trying to figure out why in 1984 taking of $500,000, it wasn't your client's obligation to figure that out, look at the books, and that one's gone. You know,
Because
the latest one happened in 1995.
because the discovery rule does not apply. Right? So when you say they have a duty to monitor the books, that's a discovery rule obligation. And the law couldn't be more clear that that is not the obligation for breaches of fiduciary duty, is actual knowledge of the wrongdoing.
So you can be a fiduciary of a closely held corporation and stick your head in the sand, not look at the books, and then recover 2 decades later? Is that your position, that the law is?
I would say yes, first of all, but that's not what factually happened here. They didn't stick their heads in the sand, and the jury heard all the evidence about this.
Right,
And
I
was
know, but statute of limitations is a legal question, right? It's not really.
It's a legal question, except to the extent that it depends on disputed facts. And so the jury hears disputed facts. The other side made essentially the same argument that Your Honor is making. And the jury heard our side say, we didn't stick our head in the sand. We were told expressly by John Tocci that the assets were being preserved. Our folks believed that. And they asked for the books and weren't given them. And so they're not under a duty. It is a discovery rule duty to go beyond that. And the jury was permitted to listen to both sides and conclude that our folks did what they were supposed to. They did enough, and that they didn't actually know about the breach. Otherwise, what you do, if you elevate a breach of fiduciary duty claim and apply the discovery rule, then you undermine the beneficiary's right to rely on these folks who you're supposed to be.
Even in the context when the beneficiary has a fiduciary duty, him or herself.
Yeah, that shouldn't, because that would be, maybe they breached their fiduciary duty to the company. But if that's true, that doesn't make the statute of limitations run. Theoretically, one could sue them.
Should we apply the same thought process then to the damages remedy, which is the jury heard all of this? It may have taken into account Justice Gaziano's point that one person was doing all the work and the others were basically free riding. And they came up with $1 million. And same reason the statute of limitations is okay. We shouldn't mess with the damages remedy here.
I just think you have to look at the facts separately. And so when one considers the facts, if there is a factual basis that the jury could have believed, either on statute of limitations or on our motion for a new trial, then those issues would be affirmed. But you have to look at the separate facts. And I would suggest on the motion for a new trial, the key there is that it's John's burden to prove these things. And for the reasons we've explained in the brief, we don't think there's any evidence of the value of the services that he provided.
Okay, thank you. Mr. Tocci. You're on mute.
Better? Thank you. Honorable Court, good morning. My case is a little more straightforward. I just haven't had my day in court. The original complaint was lodged against me by my brother John when I discovered that he had dissolved the corporation surreptitiously. I discovered that in 2013. He had promised me all through the interim years that everything was being kept in secluded, sequestered, whatever. All the assets were being kept and preserved, as Attorney McCarthy alluded to. And when we engaged in a settlement of Tocci Corporation, I came up from Virginia to work with his company, Tocci Building Corporation. Well, we worked out a settlement. In the course of that working out, I discovered that through a situation that I did a spontaneous, whatever you want to call it, examination of the Secretary of Commonwealth's online in the file, and found out that Tocci Corporation had actually been dissolved in 1995, contrary to all the representations of my brother John and any information that we had. So on that basis, I went to John, I said, listen, we're gonna have to do something about this and get down. We were in the course of negotiating settlement of what we knew were assets, were promissory notes held by my brother Bill and myself. Ultimately, John let me go from Tocci Building Corporation. I, finished my work with him there. And I said, well, I'm just gonna, at that point, I had discovered it. And I said, I'm just gonna revive Tocci Corporation, go around to our clients. I was more or less a lot of the face of the corporation. It wasn't a freeloader, as has been implied here. Building the corporation, John had nothing to do with the first several years of that corporation. It was my father and myself doing a lot of jobs, getting it going. I was the face of the corporation on site. I was the one collecting all the money at the end of the job, doing the punch list work, doing all the dirty work necessary to get the job done. I went to law school at a certain point in time, and in that period of being in school, John set up a separate corporation, Tocci Building Corporation, and over the course of the next year or so, diverted all the assets and all the business opportunities to that without disclosing that. So that's where we're at. As far as a little background is concerned.
Can I ask you about your motion to amend? That's after the trial, right? When do you file this motion to amend, and isn't it too late?
The trial was between two parties, and that's pretty express. It was Tocci Corporation versus John Tocci. There were two counts of that trial. Number one, breach of fiduciary duty, and number two, conversion. Okay, those are the only two counts. You look at the transcripts, you look at the records, look at the briefs. The court, Judge Kazanjian reiterates it time and time again. When Mr. Croft starts dealing from the bottom of the deck and starts talking about counterclaims and abandonments and things like that, the judge steps in and says, wait a minute, that's not at issue here. So those
But isn't that consistent with, you should have brought your claims? I mean, we don't usually amend complaints after trials, do we?
Well, again, like I said, as Attorney McCarthy said, this has been broken into several phases. Number one, the first phase was before Judge Connolly, was simply John's action against me, declaratory judgment. He had.
I understand that part, but once we start going into sorting everything out.
Right.
You don't have any obligation to bring your claims at that point?
None, Your Honor. I was, the judge was very express in the pretrial. That was in August. In March of 2020, we had the jury trial, which was Tocci Corporation's single plaintiff, Tocci Corporation against a single defendant, being John Tocci. The two claims, again, I don't want to get into it, but the two claims were breach of fiduciary duty and conversion. Those are the only two in the pre-trial conference. On page 33 of my brief here, I give the transcript references of this pre-trial conference. And on February 28th, it says, I'm claiming that Tocci Building Corporation is nothing more than a mere continuation of Tocci Corporation. He says, so the court says, all right, so you're asking through in that claim that's personal to you, and you're asking for a declaratory judgment, which is something the court would do, correct? Correct. So in other words, that was excluded from the jury portion of the trial. Again, at the end of the trial, the last concluding thing, I said, Your Honor, may I say one thing? Court says yes. About my matter, should I wait till the conference call to take that up, or what should I do? The court says, obviously you have matters pending. You're going to be part of that conference call with the lawyers. I will. So why don't we, between now, you figure out what you want me to do next with your matters that are pending. At that point in time, that's when I made my second motion to amend my complaint. My first motion was back in 2018, which is identical, basically, because the trial was scheduled close on. The judge said, no, it's too close to trial. Well, 2 years later, the judge, 2 years later, we finally get to trial with the matter. I hope I answered your question, but that's where we're at with that situation. So it was supposed to be basically a three-part thing. Number one, John gets his declaratory judgment action heard against me, gets denied. Tocci Corporation gets its two legal elements, which are the breach of fiduciary duty and conversion heard. And then the third phase is the equitable portions of my complaints and possibly Tocci Corporation's complaints. I'm not sure about that, but definitely my equitable complaints, which are very substantial, which is basically sounding de facto merger, mere continuation. That was in my original complaint. My original counterclaim was what stated those grounds, excuse me. So that's where we're at with my case. And I just haven't had my day in court. Everybody else has had their day in court. I just haven't had mine.
Okay. Does anyone have any further questions? Thank you. Attorney Croft.
Thank you, Your Honor. Bradley Croft for appellee John Tocci. May it please the court. Tocci Corporation mounts 3 primary attacks to the jury verdict in the case, none of which warrant reversal. The first, as has been discussed, is the application of surcharge. The application of surcharge in trust law cannot be used as a fee shifting mechanism or an exception to the American rule, and it has no application to a corporate fiduciary case. The second basis is the handling by Judge Kazanjian in a jury trial of certain findings that were made in a bench trial. And finally was Judge Kazanjian's whether or not she abused her discretion in determining that there was sufficient evidence at trial to support the jury's verdict. With respect to surcharge, it is not recognized in Massachusetts as a fee shifting device. It's only a fee reimbursement from the trust or the corporation. So at most, it provides a mechanism in a trust case to return fees back into the trust that the trustee may have used to pay for his or her defense of a fiduciary duty breach claim. There are no Massachusetts cases applying surcharge in the trust context to award attorney's fees from the breaching fiduciary in Massachusetts. All of the cases cited deal with the reimbursement from the trust to the beneficiary, not from the breaching fiduciary to the beneficiary or the trust.
So can I ask you, counsel, to address the make whole provision of the surcharge idea that monetary compensation can come from the fiduciary who's breached their duty
Sure.
to make whole the beneficiary? So
So-
here, I guess the analogy would be your client was the breaching fiduciary and his obligation is to make whole Tocci Corporation, which has now expended attorney's fees.
So the make whole objective, and this comes verbatim from the restatement of trust, which is relied upon by Tocci Corporation. It says the make whole objective of recovery from a trustee may include, in an appropriate case, the attorney's fees and other litigation costs of a successful plaintiff who qualifies for reimbursement from the trust. So again, even in those cases, it always comes from the trust, not from the breaching fiduciary. And it further states that it says that while this element of recovery is a matter of judicial discretion, however, and not a routine part of trustee liability for breach of trust. So that's a very important piece here too. It's the exception even in trust cases and not the rule. So with respect to how that might relate to Your Honor's question regarding corporate fiduciary, again, that concept has never, there is not a single case in Massachusetts or in the United States which has applied that concept to the breaching corporate fiduciary. And again, as counsel agreed, cases of this nature, I mean, courts throughout the country and in the Commonwealth are just awash with corporate fiduciary duty breach cases. One would think that if in fact this was a fair application of the law, it would have found its way by now into precisely these kinds of cases. And it hasn't, except in the derivative plaintiff context. And there it makes sense. Again, in the critical difference between—
And why does it make sense there?
Sure. In a make whole analysis, what we're saying is that for a corporation in the derivative context to recover a judgment, it took that derivative plaintiff effort, expenses, attorney's fees to require the corporation to do something which the corporation itself didn't do. In the trust context, a trust cannot by definition initiate litigation. So in every instance in which a trust is pursuing a claim against a trustee, it requires the beneficiary to act. So those are very similar, that in both of those contexts, that beneficiary or that derivative plaintiff makes sense to require that the trust or the corporation pay that person back for what the corporation should have done in the first place. In our case, the corporation did act. So there was no common fund issue. And when a corporation sues a third party because they felt they were wronged by a fiduciary, or because they thought a third party breached a contract, or because a landlord in a lease dispute with the corporation, whatever the case might be, if they recover funds, that those funds are making it whole. It's the judgment. And it's not unlike any other litigation where a litigant, a corporate litigant, expends attorney's fees in order to recover for some wrongdoing. So in addition,
Except I think your opposing counsel would say that in the third party breach of contract context, there isn't this fiduciary duty. Whereas here, you know, your client had a fiduciary duty to the corporation, and that element of trust is what brings up the idea of attorney's fees being recoverable.
sure. And I think you can look at just the notion that a duty is owed in attorney malpractice cases, in financial advisor and client cases. There are many different instances where a party is required to or decides to sue a fiduciary based upon a breach of a fiduciary duty, but that doesn't mean they're entitled to recover their attorney's fees. It would be an exception to the American rule, and it would have to apply not only in the corporate fiduciary context, but in all of those other cases in which that duty exists, if that's the policy behind it. And that's the reason we have the American rule in the first place. It would essentially eviscerate the American rule. And I believe one of the questions posed was, have any cases on those two cases, and there are only two cases that were cited for the proposition in the trust context that attorney's fees would be appropriately paid by the breaching trustee. Those two cases, one was out of Washington State, one was out of Colorado, both in the early 80s. They have not been adopted by other jurisdictions that we have found. They certainly have not been adopted in Massachusetts. And in fact, we did identify, and I believe it was Justice Kafker's question, we did actually identify one case from Arizona Court of Appeals, which expressly rejected those two cases. It's an unpublished decision, but it does directly say that those two decisions are not going to be adopted in Arizona. It's a Galbasini versus Bauer, and it's a 2010 Arizona unpublished decision. And they said, we're not going to adopt it because that would create a whole new exception for the American rule. So even in those cases, Your Honor, they are the exception still, and that was 45 years ago. One would think with the proliferation of these cases throughout courtrooms in America, it would have been adopted by now. There were certain arguments which were also made by counsel concerning that it wouldn't open the floodgates, that we would be characterizing these a very narrow subset. There is a cure to this issue, which is that number one, the parties to a corporation, a closely held corporation, could include a provision in their articles of organization that allows for the recovery of attorney's fees in the event of a breach of fiduciary duty. Number two is the legislature, as it has with several other types of relationships, including Chapter 215. So in probate court disputes, there's a fee shifting provision. Same thing in 110A for securities fraud, 93A, 176D. The legislature certainly knows how to create a fee shifting mechanism, and there is none in Chapter 156D.
In the shareholder derivative, is that provided by statute, the attorney fee payment?
I believe so, Your Honor. In section of 110A, I believe it's section 400.
Sorry, could you say that again?
I believe it's section 400 of Chapter 110A. But there's countless other statutes where the legislature has fee shifting, a wage act, truth in lending cases under 140D, and the list could go on. Fee shifting is really not appropriate in this case. And it would also, I believe, include a disincentive for fiduciaries to actually, in this context, take on that responsibility. Remember that breach of fiduciary duty and conversion claims are not necessarily intent type claims. You don't have to have a malicious intent. It can be an honest mistake that you thought you were able or authorized to take money or compensation in this case. And in fact, it's determined that you weren't. So to punish the fiduciary in that instance wouldn't serve any ends insofar as a disincentive to do that in the future.
Can you address Mr. Michael Tocci's argument about the motion to amend, that he wasn't given his day in court?
Sure. This action has been pending since 2014. Mr. Tocci was a very active pro se litigant. He was formerly an attorney, and he has, I believe it was 2018, he had filed a motion. This predates my involvement, but he filed a motion to amend to include new claims, to include new parties, and Judge Leipzenberger denied that on the basis that these were claims that could have been brought prior and that the action had been pending at that point for 4 years. Michael Tocci's claims were subsumed by Tocci Corporation taking on this case. So to the extent that he had those fiduciary duty claims, they were now Tocci Corporation's claims, and Tocci Corporation had agreed to go forward with them. At the beginning of the jury trial, Judge Kazanjian offered Michael Tocci the opportunity to examine witnesses. He spoke up and said, I am putting my case in Attorney McCarthy's hands. The case was tried, the verdict was rendered, and Judge Kazanjian thereafter said, Mr. Tocci, to the extent that you have these 2 additional claims for abandonment and de facto merger, present briefs to me on what those claims are and I'll take them up. And she essentially considered those claims, determined that neither of those claims stated a cause of action that were recognized in Massachusetts, and essentially rendered judgment on those 2 claims. To the extent that Michael Tocci, he has more than had his day in court. He has since filed, I believe, another action against Tocci Corporation's former law firm for malpractice. And I'm not sure what the status of that case is, but he certainly has had his day in court. If I may, Your Honor, switch to our affirmative appeal regarding the statute of limitations. Justice Weideland had it exactly right, which is the harm here had come home to Michael Tocci and William Tocci back in the 1980s. We're not talking even about a 10-year lapse. We're talking about a 25-year lapse between the time of the events in question and the date that they actually filed suit on them. This is not a situation where they just didn't know what the transactions were. They both had testified at various points that they realized that John Tocci was not going to recognize their ownership interest at all. And in fact, in 1991, they wrote a letter to John asking him for the books and records so that they can understand the financial accountings of the company. John did not respond to that, and he didn't give it to them. At that point in time, for a fiduciary not to say, okay, we don't have the information, it's being withheld from us, you're on notice. You have actual notice that your ownership interest, your rights as a fiduciary, your rights as a shareholder are not being recognized. And it is on you to go forward. With Doe versus Harbor, Doe versus Harbor Schools, the court had said that you cannot, we have this rule, it's a balancing, and we can't have people be perpetual defendants in waiting. A shareholder in a closely held corporation has actual notice when they realize that their ownership interests are being repudiated by their partner. And for them to say, well, I didn't realize that until I saw the specifics of certain transactions that were occurring, really doesn't jibe with the general notion that the harm had come home to them decades ago. So on that particular issue, the court should have directed the verdict in favor of John Tocci under the statute of limitations analysis. I'm happy to answer any other questions that the court might have. I know there were a lot presented in the briefs.